Malaysia's criminal justice system is entering a new chapter, one not guided only by policymakers, but by the academics that are shaping the way laws are understood and reformed. At the forefront of this movement is Universiti Malaya's Faculty of Law.
I am a criminologist and also a senior lecturer at the Faculty of Law, Universiti Malaya. I was a lawyer for about 21 years before I transitioned fully into academia.
Hazrina Begum Abdul Hamid's career bridges two worlds: courtroom advocacy and field research.
So my research is basically on crime, widely on crime, in particular trafficking, human trafficking, where I've conducted fieldwork, research, interviews with trafficking victims, on prison research, on prison as a whole, and also on counter-terrorism, where I interview former combatants, former detainees, and those foreign fighters who have returned from Syria or Afghanistan.
Her years in the field earned her a seat at the highest levels as a special branch consultant and Malaysia's first expert recognized by the International Criminal Court in The Hague. Today, she leads Law's contribution to a sweeping review of Malaysia's Penal Code, Criminal Procedure Code and Evidence Act, laws that trace back to the colonial era. As both head researcher and a member of the Prime Minister's Criminal Law Reform Committee, the team is helping evaluate everything from sentencing and bail to evidence and victim protection. Among the most urgent changes concern proposals to abolish mandatory whipping, to reform remand procedures, and to provide for digital plea options for minor offences. Within Law, the reform effort is about teamwork. 9 researchers and 4 assistants work tirelessly to study the laws from different countries, extrapolate data from interview records, and importantly, prepare recommendations for the country's policymakers.
We have a very good, friendly, strong camaraderie among us. Some of the things that we discuss about are kind of gruesome, especially, when you're talking about inflicting of punishment, whipping, but there's always a sense of calm, and we try to make it as fun as possible. I think that's the great part about my team.
The project also brings in voices from other fields. Firdaus Abdul Aziz, a medical law expert, is interrogating the role of doctors in punishment, especially when these medical practitioners are asked to certify offenders for whipping.
From the medical ethics point of view, medical doctors they have ethical duties, right? They have to prioritize. I will mention maybe the principles of non-maleficence and beneficence. What does it mean? Maleficence means that doctors should do no harm, and beneficence, doctors should do their best, to promote what is the best interest of individuals who are under their care.
To that end, he draws on his extensive experience working on global medical ethics standards at the Southeast Asian Bioethics Network, housed at Law. Global standards such as those from the World Medical Association, UN Principles of Medical Ethics, and Islamic bioethics codes all oppose doctor involvement in degrading treatment. For Law, reform must also protect professional integrity.
I hope to see a clear separation between medicine and punishment. If we can do away with the legal requirement for doctors' involvement, then that will further strengthen or safeguard public's trust towards the profession of the medical doctors.
At Law, reform is driven by the people, research, and ideas that are quietly but powerfully reshaping what justice looks like in Malaysia. Nadia Azmi, FMT.